welcome everyone. We are really happy to have John Risvold, attorney with the Collins Law Firm in Chicago, here to talk to us about pursuing bad faith cases in auto collision cases or others. But I will turn it over to John. John's helped me when I had questions about it. In other jurisdictions, it seems like it's a lot easier to pursue a bad faith claim than it is in Illinois. And we don't see a whole lot of them, but John's been successful in prevailing in a bad faith claims in the past. And so we're happy to have him here. Turn it over to you, John.
Thank you very much. Yeah, we're not, unfortunately, in California, where it seems like there's a lot of bad faith litigation and a lot of other places too. That's kind of what you get when two of the largest insurance companies in the world have headquarters in Illinois. So Allstate and State Farm are here, so they kind of make make the law, so to speak. And I'll talk a little bit about what the law is and everything else. But yeah, I'm going to focus today on just auto cases. I think that that's, for the majority of us who do personal injury work, that's the place you're going to run into the potential for a bad faith claim, and the potential for the leverage that comes with what happens when a carrier commits bad faith. So I'm going to quickly share my screen and start this. Go here. And I'll go back through it to the top. So really, what is it, right? What is bad faith? When we talk about bad faith, it's the right of the insured, the at-fault driver usually, to hold their own insurance company responsible for damages. If that insurance company somehow needlessly exposes the insured, the at-fault driver, to some sort of damages outside of the policy, meaning, in Illinois, the state minimum for auto insurance is $25,000. So if a verdict were to come in above that $25,000 against an at-fault driver, there's the possibility that that at-fault driver's personal assets, their home, whatever personal assets are accessible and easy to get, would be at risk. And that is the carrier putting that at risk if they're committing bad faith. So here's sort of the typical bad faith car crash case. And I just handled one of these, and we just settled it for 3 times the policy. And I'll sort of explain how, I'll pull the curtain back a little bit because I think it helps not only plaintiffs' lawyers, but it helps defense lawyers too. It helps you resolve cases. It helps you understand where the plaintiffs are coming from and why they can't resolve certain cases. So the typical bad faith car crash case that I've seen is the defendant rear ends a plaintiff. And it's sort of a high-speed rear ender, serious injuries, and there's only $100,000 in insurance. But the plaintiff's damages, for instance, in my case, were $200,000. She had had a surgery. We made a demand for the policy. We made it 3 times. The insurance company offered us initially $38,000. Then they offered us $50,000. Then they offered us $99,000. And eventually we resolved it for over $300,000. So this is typically what happens. And when you see the demand to settle for the policy, or the demand to settle within the policy on a case that clearly has damages above the policy, and an insurance company lowballing you, there's the possibility that you have bad faith. But it's not enough that there's a lowball offer. It's not enough that you have damages that exceed the policy. There's quite a bit of a calculus that goes into it, and I'm going to kind of talk you through it and walk you through it. So here's the process. You get a case pre-lit, you start to evaluate it, you work it up, you make your demand, you make a demand for the policy limits, and you'll use what we call Olympia Fields language. And I'll talk to you about the Olympia Fields case in a minute. That's sort of the bedrock of Illinois bad faith. But you make your demand. Then if the demand is unsuccessful, you're going to litigate. Throughout litigation, like any other case, there's additional settlement opportunities potentially. But when there's a bad faith component, those settlement opportunities are different. They're not necessarily settlement opportunities anymore for just the policy. They may be settlement opportunities for money beyond the policy limits. Then, if you're not able to resolve the case beyond the policy limits or within the policy, there's a trial. At the trial, if you obtain an excess verdict, doesn't stop there. It's not enough to just go get $1 million verdict on a $100,000 policy. It's not going to work. What you have to do then is get the at-fault driver to assign you their right to sue their own insurance. So you need to be able to work with defense counsel and potentially independent counsel for the at-fault driver in order to get this assignment. Otherwise, there's no right that you have as a plaintiff's lawyer or as the lawyer for the victim to pursue any bad faith action. You don't get to do that. Once you have assignment and you have round two, you have the bad faith litigation, which is essentially a claim brought under the Illinois Insurance Code and through breach of contract, et cetera, and you'll have a second trial. Potentially there's the same sort of opportunities to resolve it prior to a second trial, but that second trial is going to be a bad faith action based on your assignment of your excess verdict or whatever it is to your victim, your client, and them litigating that case all the way through a second trial. And so it's not enough just to get the excess. It's not enough just to set them up for bad faith. There's a whole second bit of litigation that comes with this. And a lot of what we see in Illinois, at least, is either there's a failure to get an assignment. They're very difficult to get sometimes, or people refuse and they say, I'll just declare bankruptcy. I don't care. I'd rather just declare bankruptcy than assign you this excess verdict. Oftentimes cases settle before there's an excess. They may settle for the policy limits or above the policy because the client doesn't want to go all the way, or the risk is too great that a trial will result in something that's not an excess verdict. And beyond that, there's not a lot of case law as it pertains to the bad faith litigation and the second trial because there just aren't that many that occur. There are a lot of resolution. There's a lot of settlement going on. There's also instances where some major insurance companies will pay excess verdicts. They'll just decide to pay them, as opposed to spending all the money dealing with independent counsel assignment, the bad faith trial, everything, and the litigation and everything else. So Olympia Fields is the beginning. It's the first place to start. This was the first real bad faith case in Illinois. In Olympia Fields, Alice Holliday was the injured person. She was injured at the Olympia Fields Country Club, and she obtained an excess verdict, and the country club paid it. And then the country club turned around and sued its insurance company for their failure to settle within the policy limits. And so that failure to settle within the policy limits when the insurance company knew, or they should have known, that there was a reasonable likelihood of an excess verdict is what established the bad faith failure to settle standard in Illinois, essentially the bad faith case law that we all rely on when we make policy limit demands. And what it really means is, if a carrier fails to act reasonably, and that is for the court to determine. It also could be a question of fact later down the line if you get into that bad faith trial. But initially, if the carrier fails to act reasonably and they cause a vexatious delay, and again, this is a fact-specific calculus, then you may have bad faith. But you can't be in a position where you're going to pursue a bad faith claim unless a reasonable likelihood of an excess verdict or judgment exists. So, for instance, I've seen individuals who have cases, plaintiff's lawyers, for instance, who have cases that are worth $15,000 or $20,000. They are soft tissue cases that have $1 million policies. And I've seen $1 million demands on $20,000 in medical on a soft tissue case. And it would be wonderful for the injured person if the plaintiff's lawyer were able to recover that amount of money for somebody with a soft tissue injury. It would be life-changing for them. But when you look at the calculus of it, you look at what juries are doing in Cook County, for instance, and you look at the history of soft tissue cases or cases that are worth $20,000 in economic damages, you have to understand that there's not a reasonable likelihood that that's $1 million case. There's not really even a reasonable likelihood that it's a $100,000 case in most instances. But if it's that large of a policy, there is no reasonable likelihood. Now, if you've got $20,000 in damages on a state minimum $25,000 policy, there is a reasonable likelihood of an excess verdict. It is reasonable to think that you could go get in front of a jury and get a $40,000, $50,000, $60,000 verdict. I don't think that's unreasonable at all. The other bit of the calculus comes from the at-fault driver. The at-fault driver has to be able to show that its own carrier put its own interests, that, XYZ Insurance put its own interests ahead of its insured. And then there's a duty to settle. And the duty to settle comes up when you make a claim within the policy, you have that reasonable likelihood of an excess verdict, and it doesn't really start until you as the plaintiff's lawyer, and I apologize if there are defense lawyers here, a lot of this is going to be plaintiff focused because that's a lot of where the litigation occurs, is on the plaintiff side. Until you make that policy limits demand, there really is no duty that the insurance company has to do much of anything. The other thing to be aware of, and good defense lawyers are good at this. If there are valid defenses, that easily can extinguish your bad faith. If there's some sort of valid defense, legitimate contrib, not this sort of stopped short, stopped too fast kind of contrib that we're seeing a lot of, or some of the nonsense affirmative defenses I've seen over the last year, but legitimate defenses can actually extinguish a bad faith claim. So you have to be aware that it's not just some sort of, oh, they didn't give me the policy limits and I think that I could get a big verdict. It actually has to be a balancing of interests and whether or not there is a legitimate duty that arises. So what does it mean to be unreasonable and vexatious? I think you would hear from a lot of plaintiffs' lawyers that they believe that a lot of insurance companies are unreasonable. I think you would hear from a lot of defense counsel that they believe that a lot of the demands that they see are unreasonable. There's no single factor that controls whether something is vexatious or unreasonable. There's a lot of factors, and I'll talk to you about some of them that I think are, the most prescient. They're the ones that are codified. They're the ones you can easily point to. But the courts are looking at the totality of the circumstances. They're looking at all the facts and determining whether or not the insurance company put their own interests ahead of their insured, whether or not they tried to coerce the plaintiff into settlement, or whether or not they acted in any other way improperly. There's a whole series of improper claims practices that insurance companies can be found to be guilty of, and that can help prove that an insurance company was being both vexatious and unreasonable. It's not enough for the carrier to come in on the back end and say, yeah, I know we acted unreasonably for the last 2 years and you litigated and you spent all this time and money on a case that's clearly a policy case. We're going to tender the policy. That's not how it works. If they have foregone the opportunity to settle within the policy limits over multiple occasions, probably at that point, if you're litigating, and they come in and say, all right, well, here's the policy, that does not relieve them of any duty, and it does not extinguish a bad faith claim.
John, chiming in, there's been a couple questions about whether you'll post or email your PowerPoint presentation. I let people know that we will be posting this PowerPoint on the trial practice page, but I also suggest if they want to get something directly from you, they're welcome to email you and you'll send them directly to them.
Yeah, I can give everybody my email and my cell phone number and everything else. I'm happy to talk about this stuff. I'm sort of the nerdy guy that this stuff fires me up. I really like it. I think it's really interesting. I think it's a unique area of the law, and I think it has an application to anybody that does injury work on the plaintiff or defense side. So I'm always happy to talk about it. I'll give you my email and my phone number at the end, and we can go from there. All right. And I'm happy to share this PowerPoint and any other bit of information. I've got a big file of bad faith case law and information that I'm happy to share with anybody that wants it. So I think you, Matt, like me, started on the defense side. Is that right?
Yeah, I mean, I started at a general block doing commercial litigation, but it was a little of both, but different practice.
Sure. Okay. I started doing insurance defense, and as an insurance defense lawyer, and the defense lawyers that are watching this know, there's a conflict already. And you can see it as a plaintiff's lawyer when you start sending emails to defense counsel and they're, John Smith at AmFam or John Smith at Geico. Who actually is the client? Is Geico the client or is the insured the client? And technically for the defense lawyer, it's both. But there arises sort of this inherent conflict between the two when the carrier wants to save as much money as they possibly can and the insured wants to protect their own interests. So the job of the defense lawyer and the job of the carrier is to give equal weight to those interests. One of the easiest ways to prove bad faith is to show that they simply did not give equal weight to those interests. The carrier didn't. The insurance company instead put its own interests ahead of the interests of its insured. You see that a lot in instances where, like I described earlier, there's clearly a couple $100,000 in medical bills and it's a rear end accident. There's no liability dispute, but they're trying to settle it short for short money. They're putting at risk their own client, their insured's personal assets by doing so. And they're setting up a bad faith action to come. They have to give equal weight. And at the point that they don't, that's when you start to see sort of the formation of a bad faith action.
John, another question came in. Can a coverage defense, as opposed to a liability comparative negligence defense, also extinguish a bad faith claim?
Yes, it can, with an exception. It cannot be because of some sort of minor defect in they didn't sign page 42 of the insurance agreement, or they didn't initial here or something like that. If there's a legitimate coverage dispute, that can extinguish bad faith. That's an actual defense, and it absolutely can. And I'll talk a little bit about it. There's a section 154 of the insurance code that sort of lays out and talks a little bit about those sort of coverage defenses as well. In Kramer, the Supreme Court, building off of Olympia Fields, went a little bit further and said that while insurers have a duty to act in good faith and to respond to settlement offers, they also said that there's no real common law duty to act in good faith or act fairly to plaintiffs. Really, the only cause of action that you have is controlled by Section 155 of the insurance code. And Section 155 lays out specifically what damages you can seek and how you would go forward with a bad faith action. But what the Kramer court said, and what I think is helpful for everybody to know, is that if you're not responding to settlement offers, if the insurance company completely ignores policy limits offers or any offers to compromise, then they can't turn around later and say, well, we didn't know you tried to settle the case. It wasn't our fault. It's not bad faith. Ignorance is no defense. So if they're outright ignoring demands, or you make time-limited demands and they expire and no one responds to you, that is, according to the Kramer court, a violation of their duty to act in good faith and to respond to settlement offers. And it would give rise potentially to a Section 155 claim. So what's 155? 155 says basically what I've talked about the entire, last 15 minutes or so. An insured or an assignee can recover damages from their carrier if the carrier ends up acting in a way that is unreasonable and vexatious, and a reasonable probability exists that there will be or could be an excess verdict. The injured individual cannot make this claim. You as the plaintiff's lawyer cannot make this claim. You have to get this claim assigned to you. If the defendant declares bankruptcy, extinguishes your claim because you don't have the assignment. What we always do, or my practice, is always to inform in my demand the carrier, the defense lawyer, and the defendant of the right to independent counsel. The defendant has a right to be free and independent of the carrier if the carrier is not putting their interests on equal footing. They have a right to independent counsel. And once you as a plaintiff's lawyer get independent counsel involved, and the defendant himself or herself has independent counsel, assignment becomes 1,000 times easier because you can directly contact that lawyer, and that lawyer is only working for the insured party, the at-fault driver. And they're not working for the carrier, and they have an interest in protecting their client and making sure that their client doesn't have exposure. They also have an interest in getting paid, and one of the easiest ways to get paid is to not have a client who's in hundreds of thousands of dollars debt and needs to declare bankruptcy. So getting independent counsel involved is very, very helpful. And Section 155, as the Kramer court said, is really the extra contractual remedy, the statutory remedy for when a claimant, a policyholder, suffers this unreasonable, vexatious conduct. So here's the remedy. Section 155 says that you can seek any of these three. It's a little bit murky because there is case law that says you can seek the total amount of the excess. There's also case law that says that your 155 claim may need to be the lesser of A, B, or C. But What it says is that you can receive attorney's fees and costs plus 60% of the amount of the total verdict. So for instance, if you have a $100,000 policy, but you get $1 million verdict, you can recover under 155, potentially your attorney's fees and costs plus $600,000. You can also seek punitive damages in the amount of $60,000. Or I think where a lot of what we're seeing in terms of excess verdicts and parties recovering beyond the policy is Section C, where you get the excess of the amount that of the judgment. So again, for instance, if there's a $100,000 policy and $1 million judgment, the excess is $900,000. And that is what you would seek in the bad faith action under Section 155. And again, here's sort of how you set it up. These are the improper claims practices that are set out by the insurance code. These are just some of them. There's a laundry list, but I think these are the ones that arise most frequently. The failure to adequately investigate, the denial without any evidence, the failure to objectively evaluate. Those three right away are things that you can do as a plaintiff's lawyer when you're communicating with a carrier to make sure that they're actually following proper claims practices. What is the basis for your denial? Please put it in writing. What is the basis for your belief that this is not a policy case? Please put it in writing. What have you done to actually investigate? Have you spoken with any witnesses? Have you obtained any information? If so, please provide it to me so that I can ensure that you're adequately investigating the claim. The likelihood that you're going to get any of this information is like zero. But if you ask for it and you're papering your file and you're documenting, you're creating all the evidence that you need later for the 155 claim. Failing to promptly acknowledge pertinent communications is what I talked about earlier. Settlement demands, time-limited demands. One of the biggest sort of escape hatches that carriers have and that defense lawyers have is to call you 2, 3, 4 days before your time-limited demand is going to expire and say, I really just need an extension. Can you give me an extension of time to review this? And then we'll be back in touch as soon as we've had it reviewed. And people being genuinely nice say, yeah, sure, I understand you're a person and you need time. So I'll give you time to, review the claim and review my demand and get back to me once you've had an opportunity to review it. I've been guilty of doing that in the past, but what you've just done is remove the time limit on your demand. And now you have an open demand that can be answered whenever they want. And there is no argument that the carrier ignored your demand or let it expire or anything else. My number one recommendation to plaintiffs' lawyers is do not give extensions. I know it sounds unreasonable. I know it sounds like you're being a jerk, but it's actually protecting your client and it's actually protecting the at-fault driver and their interests to the best of your legal ability. The other ones that sort of pop up, I think, a lot are they attempt to settle for an amount that is totally unreasonable. For instance, half of specials. Well, we just think the medical bills are too high. Well, my client doesn't have the option of turning to his providers and saying, oh God, the medical bills are too high because State Farm said they're too high. I'm only going to pay you half. It's not how it works. So just because a carrier thinks that something is too much does not make it so. It's what a reasonable person would believe.
John,
and again,
I got a question that maybe you'll address this, but how does, if the insurance company finds some expert to give opinions that they always give, that, this is all unrelated, it's all pre-existing, does that in of itself, eliminate the bad faith claim, or it's just a factor that a court might consider?
I think it's just a factor that a court might consider. It doesn't outright extinguish the claim. If it did, then every single time on every single case, they would just be hiring these experts to say it's all DDD and it's all pre-existing. It also, the pre-existing defense, not to jump on a soapbox, ignores basically all of the jury instructions and tries to create a defense where one doesn't otherwise exist. And so I think a reasonable court would look at it and say, well, they made the argument it's pre-existing. Aggravation of pre-existing conditions is compensable, and anything that makes somebody more susceptible to future injury is compensable. And the insurance company should know that. A reasonable person would know that because they would get the jury instructions. And so there's still a reasonable likelihood of an excess verdict. Really, what it comes down to, in my opinion, is whether or not there is a reasonable likelihood of an excess. I mean, in instances with state minimum policies, if you've got 30 or 40 in medical and you're dealing with a substandard carrier and they're making low settlement offers, or they're not immediately tendering the policy, and you've got clear damages, there is no doubt that there's a reasonable likelihood of an excess. It's just a matter of the carrier, these fly-by-night 4 a.m. advertisers know that you're not going the distance. They know that they can get you to settle your 40,000 in medical on a 25 policy for 22, because it's easier than filing suit, litigating, going through the process, trying a case that's only worth $40,000, spending all the money, spending all the time. And so
another question came up.
Yeah.
Given the example, the policy limits are 100, the insurance company offers 80, the plaintiff kind of reduces their demand to 90, but unable to resolve the case. Does the reduction of a demand below the policy limits extinguish potential bad faith?
Yes, because it's your admission that you don't believe there's a reasonable likelihood of an excess verdict. At the moment you decide to come off the policy limits means, yeah, you're trying to get the case resolved and you think that there's a likelihood you can get it settled, but it does eliminate your bad faith action because you've admitted that there isn't a reasonable likelihood of an excess. You, as the plaintiff's lawyer, no longer believe that you could go get an excess verdict. Another case just to keep in your back pocket is the Haddock case that, again, talks about it's a reasonable probability of recovery in excess of the policy limits and a reasonable probability of a finding of liability. So it's not, liability is usually certain in a rear ender, but it has to be both. It's not enough that it's possible. It's not enough that it could be. It has to be that reasonable probability. But yes, if you're coming off a policy limits demand to try to settle it, I mean, that might be the best thing for your client, but it does extinguish your right to pursue a 155 claim.
We have an additional question on that topic that I brought up. What about when the defense offers a legitimate pre-existing defense, or as a well-qualified, well-credentialed expert saying that this injury is not related to the crash, it was degenerative, notwithstanding the jury instruction that says, basically, so what, so long as it's aggravated. They've got a really well-qualified defense expert that says, look, I don't think that this was a permanent aggravation. Maybe it's, temporarily aggravated, but it's not, it's a low, whatever. It's not worth the value that we're, as plaintiffs, claiming it's worth.
Sure. I think in that case, it's really, again, fact dependent. It's a matter of how good are your treaters. You're not going to get bad faith set up pre-suit, most likely. It's probably going to be something that you set up in the course of litigation because you've given opportunities to settle. They've ignored them because they believe that they have a defensible case. Now, it's not enough to just have a defense and say, well, I hired an expert. My expert says this is legitimate, pre-existing, that's non-compensable, so there's no bad faith. If your providers, your treaters, are saying, yeah, this is slam dunk liability and there's no other possible cause, that also can put you in a position where you can make a bad faith claim. Let me give you an example. I had a case where my client was rear-ended on the highway by a drunk driver. The at-fault driver, 3 times the legal limit, tells his carrier about 2 weeks after the crash that he was rear-ended and pushed into my client's vehicle. There's no evidence of that. They were the only 2 cars on the road, but that's what he tells his carrier. My client has a mild traumatic brain injury and she needs a hip surgery. She has a torn labrum in her hip. She goes through all of her treatment for her concussion and then has the surgery scheduled. Once the surgery is scheduled, I made a policy demand. They offered me 38 and they said, we don't think we have liability because our guy was pushed into somebody else. So I made a second time-limited policy demand, both of which had expired because they either countered or ignored. They countered the first one, ignored the second one. So I filed suit. Predictably, we get through litigation and they hire 2 experts, one biomech to say that the force of the crash could never have caused this injury, and another, doctor to say that this is the kind of injury that is not caused by this crash and it wasn't caused by this crash. Both of my treaters said yes, this is 100% caused by the crash. There's no other mechanism of injury. And that was the case that we were able to settle for 3 times the policy. And here's why. We created leverage throughout the case that exposed the insured's personal assets. We had 2 ignored policy demands. After my client's deposition, I made a 3rd. After that expired, I made a 4th and gave them another opportunity. And then that's when they offered me $99,000 out of 100. After that, we filed a motion for punitives, which was granted. That left no doubt that the insured's personal assets would be at stake, and that brought them to the table. It's just a matter of documenting everything throughout the case that you believe is bad faith and building that claim as you head towards trial. Having a trial date, as we've probably seen over the last year, having a trial date is the best leverage for any plaintiff's lawyer, in my opinion, and probably any defense lawyer too, in trying to get cases resolved either in or outside the policy. Just because you hire an expert that says that your guy didn't cause these damages doesn't mean that your carrier didn't somehow act in bad faith. If they're ignoring demands, if they're needlessly exposing personal assets, for instance, in this case, we never would have filed a motion for punitives had they settled for the policy pre-suit, or had they settled for the policy at any point up into the time where they offered us $1,000 short of the policy.
John, are there certain carriers that you can share with our viewers that are, taking certain stances, like you mentioned earlier, either just paying the excess verdict if you get it, or not, or anything along those lines?
So I know for certain that State Farm sends letters of assurance to their drivers that they will pay excess verdicts. And we've seen that bear out over the last 3, 4, 5 years, that they've actually paid these excess verdicts, which is nice for the plaintiff because it extinguishes half of the case that you need to bring. You don't need to bring a second suit. You don't need to get assignment, et cetera. I know Allstate for a time was doing that as well. I don't know if they are anymore. And I know American Family was doing that for a time, and I don't know if they are anymore. And I know all 3 of those carriers have also settled cases outside of the limits in various instances. I don't know if they're doing that anymore. It's just, again, it's a very fact-specific inquiry, and it's case by case, but there are so many ways that a carrier can screw up by not being fair and by trying to lowball. And a lot of it really is because of the changes that have gone on in the insurance industry over the last 5-10 years, where State Farm is a good example. State Farm fired tons of very qualified adjusters, and they hired like college kids to do it. I mean, I'm running into adjusters who've been on the job for about 8 minutes, and they have no idea what they're doing. They're relying solely on State Farm's AI Colossus, or whatever they're calling it these days, to make their offers. They're not reading demands. They're not giving due consideration for their insured's interests. And so there's just a lot of this bubbling up to the surface because there's a lack of experience, because the carriers wanted to save money. One of the easiest ways to save money was to fire the people that have a lot of experience because they're expensive.
So this, I'll have you answer this question that someone wrote that kind of touches on what we're talking about. What do you recommend saying to clients who have a strong, what seems like a strong bad faith claim? The insurance company is State Farm, which is taking a real aggressive, position in the litigation, and this couple, doesn't have much by way of money. They could use the money to settle the case. How do you approach that sort of situation?
With honesty. And I tell the client what I believe to be in their best interest, and I give them the option. I work for them and they don't work for me. So what I always do is I tell the clients, this is the money that's available. Here's how much it is. State Farm, not to pick on State Farm, but they're big enough that they're not going to care if I pick on them. State Farm's offered you $100,000, but you've had, 2 spinal fusion surgeries, and I think your case is worth $1.5 million. That's what we would seek from a jury. You can take the $100,000 policy today, and that's your prerogative. And I would not recommend that personally, but that's your prerogative, and it's there if you want, and I work for you. And if you don't, I believe that there's a reasonable likelihood that you will get much more. And I believe that there's a reasonable likelihood that that'll be paid It's either a carrier that I know that pays excesses, or there's been documented instances of improper claims practices that I can point to if I were to write a complaint. And I just lay it all out for the client and explain to them and tell them, if we choose to not take this policy right now, there's not another option. You have to go the distance. We're not going to come up a year and a half, 2 years later and say, we've decided we want to take it. You're going to have to go all the way and get the excess judgment. And then I think it's always important to make sure the client fully informed. And so I put it all in writing for them. And if they agree, I have them sign it. And what they're signing is, I understand that there has been a policy limits offer made in my case, and I am choosing to forego this policy limits offer because I believe that the value of my case, based on my medical bills and jury verdicts and the nature of my case and the reasonable probability of a verdict, that my case is worth more than the policy limits, and I want to have my day in court and try my case. And if they're willing to do that, then you're in good shape. If they don't, to sort of step back a minute, if you have a client that is desperate for the money and they absolutely need it to survive, you have to be cognizant of that and put their interests first. And you have to just be willing to let go of the bad faith. Part of that, part of the reason why I think there's not a lot of bad faith case law in Illinois is because there is a certain segment of cases that are exactly the scenario you described. These clients are destitute because there was a crash. They can't afford to fix their car. They can't afford their medical bills. They're going to be bankrupted. I mean, bankruptcy, medical bills are what, the number 1 or 2 cause of bankruptcy in the country. So those segment of clients, you have to be aware that even if there is bad faith, and even if you think you've got a slam dunk, it might not be in the best interest of the client. And it's always important to remind yourself that we work for them and we have to do what's in the best interest of the client. And if we're not doing what's in the best interest of our clients, we're doing exactly sort of the bad faith type thing that we're accusing the carrier of doing, which is not acting in the best interest of their client. And so it's always important to not be guilty of what you're accusing others of.
Just one more question that came through. I know you recommended not giving extensions on policy limits deadlines, but if you do, you give an extension, there's a new deadline, that in of itself is not going to blow your bad faith claim if they end up, blowing that new deadline. Okay.
No. The language that I always use, I stole it from a California lawyer, and he does a lot of bad faith work, and who I respect him quite a bit. His name's Nick Rowley. The language I stole from him is that, this demand will expire on X date at 5 p.m. Any communication after 5 p.m. will be considered a rejection. Any counteroffer or any offer less than the amount demanded herein will be considered a rejection. That way, you've made it clear to the carrier that this is not a negotiation. It is a tender of the policy. They have an opportunity to buy a release from you for the full amount of the policy. And this is the last opportunity they're going to have to do that. Now, it's not enough to bluff. You have to be willing to go the distance. And that sort of leads me to the next part, right? Is while you're working it up, there's a lot that you can do. And I'll share this. I don't want to go through bit by bit and bore you. I mean, you guys can all read. But begin at the beginning, right? You're putting the carrier on notice with your demand. You're making sure they're time limited. The number one thing that I see in my practice that sets up bad faith is ignored demands. But use that section 154 to highlight the improper claims practices. And I always like to give the carrier one more shot. You send your Olympia Fields demand. They either counter, they ignore it, it expires. I give them another 14-day window before I file. And I say, and this is just me, right? I always give them sort of a 14-day window. I let the demand expire at 5 p.m. on a Thursday, and I file suit at 8 a.m. on a Friday. We're not playing games, right? And the carriers understand that, and they know that, and they will start making more reasonable offers. They will start making policy offers when you can show them that you know that you have a claim here. And this is the language that I use, and I tell carriers and defense lawyers who've dealt with me have heard me say this before: policy's open. There are no limits anymore once you've committed bad faith. You've acted in bad faith and I have it documented and I believe that it's documented, the policy's open. And so what I do at that point, and again, this is sort of some inside baseball plaintiff's lawyer stuff. What I do at the point where I believe that I have bad faith is I make a true value demand. I send to State Farm, again, I'm picking on State Farm. I send to the carrier, the defense lawyer, all those money interests, and anyone who has money in the game, any other umbrellas, whoever it might be, and the defendant, him or herself, an email. And I like email the best because people respond to their emails. People get a letter, they set it on their desk, they throw it away, they put it in a file. Your email's on your phone, your email's on your iPad, your email's on your computer. You're always seeing it, you're always checking it. I send them an email and I say, you've had 2 opportunities to settle this case for the policy. Here are the damages. Here's the JVRs that are comparable cases. Here's our theory of liability. Here are all the cards in my hand. And here's the true value of the case. You have 30 days to pay it. And they won't. And then you have yet another opportunity where you've shown them, this is what I'm going to ask a jury for. This is what I think the case is worth. You know now what the risk to your insured's personal assets are, and you're still choosing not to act in good faith. You're still choosing to act in bad faith or to ignore these policy limits demands. Then we're going to move forward with an open policy. The policy limit does not exist, and we're going to go the distance and get an excess. You have to be willing to do that in order to get these excesses in most circumstances. And I say in most circumstances, 99% of the time, they're not going to settle outside of the policy. I mean, maybe some of you have experienced settlements beyond the policy where you haven't had to try a case, but 99% of the time, they're not going to do it. I recently, in my opinion, lucked into and worked hard into a settlement in excess of the policy, but we were going to try that case a week later, and we knew with certainty that if the case came in half as good as we thought it would, we were going to get an excess because we had all of our ducks in a row. We had everything that we needed. But you have to be able to go all the way and get the excess. And once you have it, then the hard part is getting the assignment. And I was just on a case management call where 2 attorneys were going through this, and the plaintiff's lawyer was beyond frustrated because the defense lawyer continued to reiterate, my client's just going to declare bankruptcy. He doesn't care. You're never going to get an assignment. It doesn't, there's nothing you can say that's going to get us an assignment because they're just going to declare bankruptcy. These are some of the risks inherent with getting the excess, trying cases, and spending the money trying them to get these excess verdicts is that there's escape hatches, right? There's Section 155, which I think removes a lot of the teeth for plaintiffs because there's no real punitive component. This is punitive conduct. In my mind, there's no doubt in my mind that what carriers are doing is punitive conduct, but you can only seek $60,000 in punitive damages. That's a rounding error for some of these insurance companies. So it's a little bit toothless, and there's escape hatches. There are ways that they could show that they actually had a legitimate defense that they never made you aware of, like we've discussed earlier, or the defendant just declares bankruptcy and you're stuck. You don't have an assignment. But if you get it, I think we've talked about all this, but you get it and then you proceed to the next step. There's no direct action. This is why I always want to put on notice, the defendant on notice, that she has a right to independent counsel. Really important because that really helps grease the wheels to get your assignment.
John, just to hammer that point home, we had a question about, how can you communicate to the defendant's represented? What you're saying is, you put that in your policy demand that's sent to the defense counsel. You ask that it be forwarded directly to the defendant, and he or she be put on notice that their personal assets are at risk, and seek independent counsel, and then even at his or her deposition, if you get that far, maybe put that demand in front of him or her again. Are you aware that he made this demand? That sort of thing, right?
Yeah. So I'll take it in 2 steps. Every demand that I send, every single one, is addressed to the adjuster. If there's a defense lawyer involved, the defense lawyer, all money decision makers at X insurance company, and the defendant at fault driver, him or herself. And in the body of the demand, every single time I say, if it's a policy demand, I say, please immediately forward this to your insured so that they may review it and they may seek independent counsel because they have a right to independent counsel. It is clear based on the actions of the carrier that there is a conflict between the carrier and its insured, and the insured needs independent counsel. Please let me know who that independent counsel is, or advise your insured to have their independent counsel contact me as soon as they're hired. That way, you've sort of set it up for part two, which is the deposition, which I think every smart plaintiff's lawyer should ask the following questions in a deposition. Are you aware that we made a policy limits demand in this case? Yes or no. Have you ever seen it? Yes or no. Are you aware that if you instructed your carrier to settle this case for the policy limits prior to this point, you would have been able to avoid this deposition and all this litigation? Yes or no. And then show them the demand and say, have you ever seen this? No, you've never seen this. This was never shown to you. Are you aware that if we obtain an excess verdict, that your personal assets, your home, your cars, your retirement accounts may all be at stake? We may be able to collect those. You may be bankrupted. Are you aware of that? Are you aware that your insurance company is doing that to you? And just see what they do. See what they say, right? The conflict exists between the carrier and its insured. And so all you're doing is highlighting the inherent conflict and showing that the carrier doesn't care at all about their insured. They care about their own pot of money. And in caring about their own pot of money, they're really putting this other person at risk. And so I love to do that in depositions. Every one of those questions will get objected to. You're going to piss off every defense lawyer you ever have a deposition with when you do that. But I think they're important questions to ask because it helps your client. And that's what you're doing. You know, that's what you're here for. It helps your client, but it also helps you paper the file. Now you got a transcript that the insured never even knew there was a demand. Okay, well, that's exhibit A to any 155 lawsuit that I file after I've obtained an excess. It's just about creating and papering a file. I think any good defense lawyer or anybody who's done any sort of corporate work or any commercial litigation, especially, like I'm sure you know this, like the devil's in the details, right? Like some of the best stuff you're ever going to find is in the documents or in a privilege log or whatever else. The same holds true with Section 155 claims. Some of the best stuff you're going to find is in email correspondence with carriers. It's in the claims file itself if you can get a copy of it after you've had an excess. And all of these sort of bits and pieces come together to form your case. It's not going to be made on one missed demand or made on, one lowball offer. It's going to be made on sort of a confluence of things and the totality of the circumstances. And so the more improper claims practices you can point out, the more 154.6 violations you can show, the stronger the claim is, the greater the reasonable likelihood is of an excess and a reasonable likelihood of liability, and the stronger a 155 claim is going to be, which again prompts carriers to come with more money than they have a policy for. And so that's sort of my strategy and my take on how I view car accident cases and the bad faith component. I'm happy to answer any questions anybody has or anything else. I'm happy to share all these materials. I think that it's a very simple, methodical sort of process you can go through, that you should go through, because one of two things is going to happen. The value of your cases is going to go up and you're going to get more policies, or you're going to try more cases, you're going to get more excess verdicts, and you're going to have 155 claims. One of those two things is going to happen if you start papering your file and acting a little bit more like a defense lawyer. Like everything a defense lawyer does is papered and sent to the carrier. Every single thing they do, because they have to justify how they get paid.
John, any suggestions on if you go the distance and you get an excess verdict, how do you go about getting that assignment in the case where you don't have an independent counsel? At that point, I mean, are they still technically represented by this counsel? And can you send an investigator out? Can you contact that defendant directly? What are your thoughts?
I think that one easy way to do it is in trial, and to just loudly explain to defense counsel repeatedly over the course of several days, if we obtain an excess, your guy's going to be personally at fault. Your carrier doesn't want to come with more money. You really don't want to come and bring reasonable, fair justice value to this case now before a jury puts his personal assets at stake. You would have already talked about it at the deposition, so they know it. You would have already told them of their right to independent counsel at that point. and you're just reiterating it. Once you have a judgment, they're not represented anymore, technically, and you have an action, to recover that excess yourself because you have a judgment against them. So what you can do is start judgment proceedings, and then once they come to the judgment proceeding and you're going to do your citation to discover assets or whatever you're going to do, you've got a judgment order, you start the judgment proceeding, you begin with your motion for leave to discover assets, right? They're going to come either with independent counsel now, new counsel, or they're going to come themselves and just outright explain to them, especially if they're representing themselves in the judgment action, explain to them, look, I can dismiss all of this if you just assign me your right to sue your carrier. And here's a document that says that you assign that right to me, and I'll dismiss all of this right now, and I won't pursue this judgment against you because I'll have an assignment of this 155 claim and I'll pursue it against the carrier.
We have one question on that.
Yeah, I see it. No, and he's right. So be careful. You don't have a free and clear defendant if there's post-trial motions pending, if there's an appeal, if there's still action on the case, right? You don't have it. And I think it's really important to reemphasize that point. Like, do not go talk to represented parties if they're still represented and there's motions pending or there's an appeal, right? Be patient. This is a very long process. It takes a very long time to do it right. And you just have to be patient, right? I know we all want to get our clients paid and we all want to get paid quickly and we all want to resolve cases quickly and everything else. But this is a process that is methodical. It takes a long time to do it right. And you want to be sure you're not committing malpractice. You want to be sure that you're not acting in bad faith yourself. You're not jeopardizing your client or anything else. And so the best move is always to just be patient, right? There's a statutory prescription for how long they have to file post-trial motions, how long anybody has to appeal. Wait,
I assume as a plaintiff's lawyer, our statute of limitations on a bad faith claim is not going to start ticking until when we get this excess judgment or
when you have a final judgment on the merits. So that would be after either post-trial motions are decided or an appeal, right? And so once you have the entry of the judgment order and it's finalized and everything is good to go and you're free and clear, then you don't have to necessarily worry about that as much. If you're not already getting the assignment right away because they want to get it off their plate and they know what's up, you're going to get it later down the road when you try to enforce that judgment.
Someone had a question about discovery that you might be able to get from a carrier in the bad faith litigation. I mean, you mentioned how you might ask for certain things in the underlying litigation and you're going to get all kinds of objections and probably not going to get anything. But when it comes, if you go the distance and now you got your assignment and you brought a bad faith claim, what sort of discovery can you get?
I want the whole claims file. They're not going to give you the whole claims file probably. But again, a lot of, I think what you're going to deal with in that instance is motion practice. You're going to have to file motions to compel to get a lot of this stuff. But the real good stuff is going to be not just in the adjuster's analysis and their claims notes and everything else. It's not just going to be that adjuster Susie Smith viewed the case a certain way. It's that she ran it up the flagpole and her boss and her boss's boss might have seen it. I mean, there's a really good 5th District case about exactly that, where, and I'm struggling to think of the name of it and I'll find it and I'll include it with my materials, but it's essentially that. There was a case where an adjuster thought a case was worth like 40, 50 grand maybe. It ended up being a $3.5 million verdict. And what had happened was the initial adjuster said, this is clearly a policy case. We have $1 million policy, turn it over. Went to get authority from the boss. The boss said, yeah, this is clearly a policy case. We need to get authority, but it's above my authority. And it went literally all the way up to the president of the company. And the president of the company looked at it and said, we're not going to pay policy on this. No, we'll offer him like 50. And the president of the company, the president of the insurance company said, this is the lowball offer we're going to give him. And the court said, look, everybody along the way, yes, it's the Buckner case. Everybody along the way said, look, you got to turn over this policy. It's clear as day. And so you're going to find that stuff in the notes. You're going to find that in email correspondence. You're going to find that maybe in text messages. All that stuff like most case management systems that we might have as plaintiffs, right? If you draft something, it gets saved to the file. And so you want all that. You want texts, emails, the entire claims file, every bit of it. You want, if you can find them, and you may need to turn to listservs, or you may need to turn to, friends and family or whatever. If you can find claims manuals for any of these major insurance companies, I don't care how old they are or how outdated they are. If you find a claims manual for any of these, hold on to it for dear life, because that will give you so much good evidence for depositions about how exactly claims are supposed to be handled. And essentially at that point, you've got a rules of the road case. You've got, here are the rules that, State Farm laid out for you. It's in this manual. You were trained, right? Presumably, hopefully you were trained, and here's the manual. Did you ever read the freaking manual? Did you ever bother to look at it? Did you refer to it while you were handling this case, et cetera, et cetera? And again, you end up with a lot of damning testimony that way. So
there's a question about, can a court in post-judgment in order somehow turn over the bad faith cause of action to the plaintiff? Or does it?
I've never seen that. I don't think there's any mechanism in Illinois law for that I've seen. Yeah. It'd be awesome if judges took it upon themselves to tell litigants, hey, you're screwed unless you assign this to the plaintiff's counsel. I mean, I think that would help a lot of litigants. I think it would help a lot of defense counsel too, because they're in a bind, right? Because they're getting marching orders from a carrier who's acting in bad faith. So,
you mentioned Nick Rowley. Just I know you would echo that advice to check out the book "Running with the Bulls." Right, has great examples of policy demands, albeit he's in California and the law's more favorable there. But that's a good starting point. I'm sure you'd be happy to share any demand letters that you use.
I will share any demands that I have. I'll share any information that I have. If you're a plaintiff representing injured people and you don't own Running with the Bulls, you're committing malpractice. That's my opinion. I think it is that valuable. I think it is the most valuable book for settling cases and for potentially setting up bad faith that exists. And I'm sure I just told a bunch of defense lawyers that, and I'm sure that is bad, but it's that important of a book, in my opinion. That, and anybody wants to reach out to me, my email is jrisvold, it's RISVOLD @collinslaw.com. You can email me. You can call me on my cell phone. It's 816-896-5749. I'm always working, much to my wife's chagrin. I'm never not working. I'm happy to talk about this stuff. I, weirdly enjoy it. I think it's really interesting. I think it really gives an opportunity for us as plaintiffs lawyers and for injured people to sort of level a playing field a bit. I wish that 155 had a little bit more teeth like California does, where you get punitive damages and you get statutory interest if you beat your demand at trial and that sort of stuff that we don't really have yet. Hopefully someday we will, because I think that stuff's really valuable for victims. But for the time being, I'm happy to share anything that I have and everything that I've learned. I'm not the only person that knows this stuff. I'm certainly not the authority on it, but I'm happy to help because I've had some success getting beyond the limits and opening policies.
John, good question here. Does this same analysis that we've talked about apply equally to UIM claims?
Untested. Yes. And I'll give you my most recent example. I had a UM. We got a great ARB award. State Farm again. State Farm rejects. And I, before they had an opportunity, they sue me, right? When they reject, they technically sued my client and I become the defendant. And I filed a Section 155 counterclaim, and it withstood a motion for summary judgment, and it withstood another motion to dismiss, and it's still pending. And so when we get to the trial de novo in the UM or UIM rather, as of now, I will have an opportunity to present bad faith, my own bad faith counterclaim. And I, in that litigation, have sought the same sort of stuff we've talked about in discovery, claims file, emails, all that good stuff, certified policies, et cetera.
Yeah, but how about these UIM claims that are subject to mandatory arbitration? So
Yeah.
what, any thoughts there on how you handle that? If it's a clear policy limits UIM claim and.
There's a Seventh Circuit case, and I don't remember the name of it. There's a Seventh Circuit case that I know for sure says that the Arbitration Act controls, and Section 155 does not apply. I'm not certain off the top of my head whether or not there's an Illinois case that says the same, but just go look for it and find it. I haven't found it. I haven't seen it, but I know there's a Seventh Circuit case that says that.
Another question, are you aware of any data on which carrier has the most bad faith claims in Cook County?
I don't know who has the most bad faith claims, but I would be willing to wager a friendly amount that it is the same carriers that are advertising after midnight. If you have to ask a listserv, is this a substandard carrier? They probably have committed bad faith in the last month. That's just my ballpark guess. Any adjuster who says, can you cut me a deal on a case that's clearly, beyond the policy limits is committing bad faith, right? And how many American Access or American Alliance or American Freedom or American Eagle or whatever they are, right, is doing that to you on a daily basis. So the subs are the worst, right? They're always going to be the worst. But I think over the last year, as things have changed and evolved and everyone has sort of clutched their purse strings a little tighter, you're seeing more and more of it from big carriers. And I mean, they're even ignoring counsel. I've got an open policy now where 3 separate times we went to court because the defense lawyer had recommended that we settle for the policy, told the court that, said, we're going to get the policy. We need to settle it for the policy 3 different times. And then we just proceeded to litigate. Like it just never happened. When they're even ignoring their own counsel on, very clear, this is a rear ender with a couple fusions. So super clear, that's textbook kind of stuff. Right. And so it's just a matter of papering your file and setting it up and being patient, being prepared.
Good stuff. John, I'm not seeing any other questions. If anyone has them, type them up quickly. Otherwise we're going to let John go. This has been great. And you guys all have John's information. If you have follow-ups, and I think, we got one more question.
All right.
Good job. It wasn't a question.
Oh, hey, thanks. Sorry. That was like a little bit of encouragement. That's good. I don't think we get enough encouragement as lawyers. I think it's mostly just everybody's mad at you all the time. So that's nice.
Cool.
I appreciate it. Thank you very much for letting me come on and blab at you guys for the last hour or so. I hope it helps your cases. I hope it helps your clients. I hope the values go up because rising tides, right? The more, $100 million verdicts or $20 million verdicts that everybody gets, the better my cases get, right? Because I have more leverage. So, yeah, hopefully it'll help. And if you ever need anything or you ever have any questions or just want to kick around ideas, I'm always open to that. And like I said, Matt, I'll send you everything that I have if you want to share it with everybody. And
yep, I will post your PowerPoint on our trial practice committee page. But if you want it sent directly, reach out to John. And thanks again, man.
Awesome. Hey, thank you. Take care. Stay warm.
All right. Take care, everyone.